Your wedding begins here. You've found your person. Now find your perfect place. Welcome to Marin County, where your love story meets its perfect setting. Exchange vows beneath ancient redwoods on a sun-kissed beach or overlooking the sparkling San Francisco Bay. Whether you're planning an intimate elopement or a grand affair, Marin offers the space and the spirit to make your wedding uniquely yours. Discover where forever begins at visitmarin.org and explore the weddings page for details.
Welcome back to Come Back with a Warrant podcast. I'm Brandon Dinitz.
And I'm Monica Ashak. Before we kickstart this week's episode, this is your reminder that this podcast is not legal advice. It's real, unfiltered, and for entertainment purposes only. If you need to speak with a lawyer, call one. Or better yet, call us. Welcome back to Come Back with a Warrant. I'm Monica Ashak.
I'm Brandon Dinitz.
And today we will be talking about surviving a pre-arrest investigation. This oftentimes comes up when someone's at work and they get a call from usually law enforcement, and that officer is interested in talking about something related to potentially a crime that someone was involved in. And that's usually when the first stage is like when you're supposed to really call a defense attorney at that point.
Correct.
And that's because law enforcement is beginning their investigation, continuing their investigation by trying to get more evidence and contacting the potential suspects.
And at least with that first initial phone call that someone gets, they do not know what the status of that investigation is. The people that are getting that phone call that are the subject of the investigation really only know what the officer is willing to tell them, and officers are allowed to lie and kind of use trickery to confuse or mislead people to have conversations with them.
Yeah.
A lot of people don't realize that cases can be won and lost right here.
Yeah.
When you have the opportunity to intervene as a defense attorney at the investigation stage, that's one of the places you can be the most impactful. Before the case has become an arrest, before there's been the need to speak to the state attorney's office about making a filing decision, when it's just the investigation and it's just the initial beginning, there are a lot of things that can happen.
Yeah, I agree. And that is actually the first opportunity that our role, defense attorney, can actually, just like you're saying, make an impact on the case, but more so in the actual investigation. So for instance, if they're trying to retrieve a statement from our client or that person who they're calling, they usually are also introducing themselves from whatever unit they're involved in. So then you kind of get an idea of what it is they're investigating. You know, if it's violent crimes or special victims unit or whatever it is, you kind of get an idea of what type of case they are investigating. And they don't usually disclose exactly what it is that they're looking for. So they'll be like, hey, we just have some questions. If you don't mind coming down to the station, we can just talk about it. It's super casual. And they try to be very, I think, friendly to the person they're trying to get a statement from, because at that point, they're not informing them that they are usually the subject of an investigation. That information usually comes out when they are already at the station or in front of the police in person. And then that's when I think things maybe start snowballing, because then they can start saying, like, we have this video of you or whatever it is, even if it's not true, because they're able to, like you said, be dishonest and use whatever they get out of whatever dishonesty they present or misrepresentation they said against the person that they're getting it from. So whenever you get an attorney involved, that's when we're able to be like, do you have a warrant? You know, we're invoking our right. If they're you know, a suspect, they shouldn't, you know, we're not going to be giving statements.
And we're talking about when we talk about the rights that we're invoking, as defense attorneys at this point, we're invoking our clients' Fifth and Sixth Amendment rights.
Yeah.
Okay. We don't want them saying anything. So the right against self-incrimination
Exactly.
and the right to counsel, the Sixth. We are explaining to these officers that at this point we are involved and they can direct all communication to us.
Exactly.
Then we try to figure out what's going on. Mm-hmm. We can start asking questions and we can be very frank with law enforcement. We can share things that we want to. We can withhold information from law enforcement that we want to. Often it is like two dogs at a park sniffing each other and trying to figure out what's going on.
Yeah.
clients that come to us and they are in this process, it's so important that they get to us early because we are able to tell them, hey, don't have these conversations, at least without us, present. They are building a case using you. They either have the case already built and they want the cherry on top, or they don't have any case built and they're using you to set the foundation of what the case is going to be. But either way, we don't want our clients being the one that are trying to figure that out.
Exactly. And I was thinking, I don't know if this might sound obvious maybe to other lawyers, but I don't know if many people know that because once your attorney steps in, anything we say is not, even though we are their voice in a sense, it cannot be used against our clients. So if we're saying, if we're representing something to either the state or law enforcement in this case, that's not something that can come later and be used against your client. So that is also another benefit to having this person representing you as your kind of shield between you and law enforcement or you and the government, especially in those stages, because this is the opportunity that you have to kind of block any opportunity for the government to come then and charge you with any crime that they're investigating at that point. Obviously, they can apply for search warrants and get things kind of even despite our efforts in stopping that. But I think that, even if they do get that warrant, you have an attorney to then review the warrant, make sure it's sufficient, or if there's any issues with it, you can address it then. And then they sometimes will give you a heads up as to warrant so they don't raid your client at work, or if you have that, I find that there's kind of this switch with law enforcement once I get involved. It becomes a little less aggressive from their end because they understand that this person is taking it so serious that they went and hired counsel at this point, and that they are going to be checked if they are doing anything kind of the wrong way or they stray away from what proper procedure is. So I find that most of the time, whenever I step in, law enforcement is usually friendlier with me than they were with my client when they were calling them initially.
That's fair. And I think the law enforcement, speaking with defense attorneys, there are a lot of different approaches and angles, right? Mm-hmm. You expect from movies and TV that the defense attorney's coming in all hot. I'm invoking my client's rights, figure it out, pound sand. In reality, we want to know what's going on.
Yep.
The law enforcement officers can tell us what's going on. They can give us the breakdown of what their case is, what the investigation is. And oftentimes there is going to be a point where we do need to coordinate something with law enforcement so they know there's a professional on the other line that I'm coordinating with. If a client has to turn themselves in or if there has to be evidence turned over, etc. That can be coordinated between the officer and the defense attorney, and that makes the process less hostile and a lot less dangerous. Because if you can coordinate when your client is going to be turning themselves in, that avoids them being arrested and something potentially bad happening during that arrest. Yeah. We see that all the time, that arrest warrants being served, things happen left and right. We've had cases against each other where there's been an arrest warrant being served, things happen, and other people get charged. It can get out of hand. So knowing that there's that ability to speak with the defense attorney and coordinate makes things easier. The relationship between law enforcement and defense attorneys is important. And one of the things that we do, and we definitely talk about on this show, is the other viewpoint, like kind of what's going on. If we look at an investigation and we start looking at the investigation point from the side of law enforcement, what are they doing by the time they reach our client? Mm-hmm. Well, how does the investigation start? We know that there's some sort of complaint, allegation. There's something that the police get information on and they now need to investigate, whether that's a 911 call, whether that's a neighbor calling in a complaint. We don't know exactly where it's coming from, but that's how it starts. They go out, they start their investigation, and we hope they do a thorough investigation, that they're looking into any allegations that are being made. They're checking the credibility of those allegations. They're looking at evidence. If there's surveillance or if there's other people to talk to, they're doing those things. And then comes the interaction with our client. Okay. Yeah. When we get to that point, any number of things could already be happening. They could be ready to send the case to the state attorney's office. They could be ready to arrest our client, or they could just have somebody's word that's an alleged victim, and then want our client's word to see if it's a he said, she said type of situation. And it could be anything at that point.
Yeah. And the times where I have experience where they're at the stage of ready to arrest.
Head to Safeway this week and enjoy these amazing deals. Clip coupons from the weekly mailer or download them from the Safeway app to breeze through checkout. Post cereal, Quaker cereal, or instant oatmeal, Pop-Tarts, Rice Krispies treats, Welch's fruit snacks, Nature Valley, Nutri-Grain, or Quaker Chewy bars, and General Mills cereal, various sizes and varieties, all just $1.99 each when you buy 4. Earn 4 times points on Juicy Sumo citrus fruit, just $2.99 per pound. Visit Safeway.com for more details. See you in the aisles.
Usually when we coordinate a turn-in or coordinate for a meet for them to either receive like a notice to appear or whatever it is, I find that they've been more likely to give them a notice to appear, which is effectively the same as an arrest. You get your court date, but you don't go into custody. So that's also something, obviously, if it's not a super serious case, if it's a serious case, they're going to be arrested. But if it's, maybe a misdemeanor they're investigating or a lower level felony and this person doesn't have crazy history, because that's something that also can be considered by the officer. They have discretion to issue a notice to appear versus an arrest. And I have found that it is just so much more beneficial to the client in general if they seek counsel from the jump. And this was something that I actually didn't have experience with at the public defender's office, and same probably with you at the state attorney's office. I know you guys had I think like a week where you were on rotation for certain things, which you can talk about because I'm not like really privy to that information, or the process. But the public defender's office, you get appointed at the first court date, so you're not really involved at any point prior to arraignment, or if it's first appearance that you're handling, whatever it is, you're not appointed prior to that. So you don't get to see the inside of what a pre-arrest investigation is until you go into private practice. So that was something that was kind of new for me when I went into private practice, where I was like, oh, okay, like this is really my opportunity to do anything I can outside of court with law enforcement, because at this point, state attorneys are not involved when it's pre-arrest. They are not involved in this process unless it's like what they're called out to the scene on the night of the crime or something, and they're applying for a search warrant. But like things like that, that's usually they're not involved in the process of coordinating a turn-in date. They're not in the process of the investigation of law enforcement, of who they need to speak to, taking a statement, and all those things. It's usually just the defense attorney and law enforcement. So at that point, it's just so important to not only retain counsel, but listen to, I think more than any other stage in the proceedings, like post-arrest, the most important time to listen to your attorney is during that time, because you can really avoid a lot of like issues for yourself, even like you said, like in the process or with the actual evidence for your client. So I think that's huge. And it's really, the onus is on them. Like they have to be like, okay, I think I should probably call a lawyer,
Yeah. And one thing I'll touch upon, as a prosecutor, I got to see certain parts of the investigation stage. When you are at the state, there is a rotation of people that are on duty. And the on-duty prosecutor gets phone calls after hours from law enforcement that are seeking a warrant, whether it's an arrest warrant or a search warrant. And those calls come into the prosecutor. The prosecutor has to weigh whether or not they believe that this is the type of situation where an emergency warrant is required. And if so, the warrant is written up and drafted by the law enforcement. It goes to the prosecutor to take a look at. The prosecutor approves it. It gets sent from the prosecutor to a judge. And it goes, or from the officer to the judge directly. And then the judge reviews it and then signs the warrant from their computer. There's really no more. There's still the concept of, hey man, you got to go wake up the judge.
Right.
That still exists, but it is a lot more computer involved now. It's wake up the judge with a phone call, and then the judge logs onto their computer, checks the warrant, and then signs it. Sometimes the police do show up and meet the judges in person in the middle of the night, and they sign warrants. It all does happen like that. But as far as being a prosecutor, I was privy to the investigation at that stage in certain cases, but really only when I was on call. Otherwise, I wasn't privy to anything that happened pre-arrest. When I became a defense attorney, I learned how important it was and it is to be involved pre-arrest. If I can get involved and I can speak to the officers, there are occasions where there's information that I can provide the officers that will lead to my client not being arrested at all. Yeah. And the charge is not occurring. There's sometimes information, a lot of times it happens in leaving the scene of an accident cases, where I can provide the officers with information and my clients ultimately do not get charged.
Right.
Or there's information that they already have that I can either tell them is accurate information, meaning, again, in leaving the scene of an accident is the case where a lot of times there's heavy pre-arrest involvement. Yeah. Things come up all the time where you're speaking to officers about the owner of the vehicle, potentially who was in the vehicle, and a lot of those conversations can be had and your client's not involved in those conversations. And depending on how they go, the officers may realize, okay, well, barking up that tree going after that person isn't the right move at all. End the investigation and it's done there. And your client never has to see the inside of a courtroom or jail or anything like that. That's the best case scenario as a defense attorney dealing with the investigation.
Yeah,
right?
For sure. And the other part is having the ability to later say if it doesn't go in that route and you end up getting arrested for any reason, if you have somebody that's checking police and being able to be like, okay, that's fine, whatever, or we'll coordinate a meetup or whatever, all of those scenarios can later be used in front of the judge to say that you were cooperative throughout the investigation, even though you were invoking
That's a great point.
Your rights. So like that is something that invoking your rights can never be used against you in later proceedings.
Right.
But what can be used against you is that you were not cooperative. You were not, whatever you were asked to do, you to make it easier on you for the process in terms of like coordinating a turn-in, let's say, versus them getting an arrest warrant and coming to execute it wherever you are, whenever. Mm-hmm. And that's something that actually the courts consider. And I think that it's weighed heavily whenever you're asking for a bond release or any sort of like mitigating circumstances. You can always point to things that happened pre-arrest where you were actually involved in helping in a way, not helping them. I don't want to say helping law enforcement arrest you, but kind of cooperating in terms of getting the process done for everybody.
Right.
involved.
So it's not a violent incident.
Right.
And the other thing is, I talk about this in other places, but when you are getting arrested, your behavior while you're getting arrested is going to impact your case. And I tell this to people all the time. Screaming that you know your rights, screaming about who your father is or that you're going to sue them or that wait till, your lawyer gets them in court, none of that helps your case. And it oftentimes makes things worse for you.
So much worse.
I have never had a client that I've surrendered behave that way during an arrest. No. And I think ultimately the people that self-surrender, the process is a lot smoother.
Yes.
Often they're going into custody and coming out of custody is 1, 2, 3. It's a smooth process. There's nobody that's concerned about their safety. I've turned over clients right to officers and they've, put the handcuffs on the front of them and they've walked them into the jail. Like it's a very different scenario than what you see on TV where people are having these crazy reactions when they're getting arrested or they won't refuse to get out of their car and then it becomes just chaos. When you have a defense attorney, those things don't happen.
Well, yeah, and you also have the opportunity to mentally prepare your client so they kind of know what they're getting themselves into prior to, and you explain to them the benefits of doing this.
Right.
So understanding that, they have a huge incentive to just zip it and not act out. And that, everybody, it is on TV, but I do see it on body worn camera whenever I get my evidence sometimes. I'm like Like, why? You know what I mean? Like, just let the defense attorney handle everything when it gets to court, because at that point they've already decided to arrest you. Nothing you say at that point will keep them from arresting you. If anything, you're giving them opportunities to charge you with resisting, or resisting with violence, resisting without violence, whatever it is. Or if you give a false name, that people do that sometimes, you know, that's obviously, if it's pre-arrest, that is unlikely to happen. But it's just the way you act, like you're saying, like during arrest is huge, and you're really giving either yourself or them an opportunity to act accordingly. So
Your wedding begins here. You've found your person. Now find your perfect place. Welcome to Marin County, where your love story meets its perfect setting. Exchange vows beneath ancient redwoods on a sun-kissed beach or overlooking the sparkling San Francisco Bay. Whether you're planning an intimate elopement or a grand affair, Marin offers the space and the spirit to make your wedding uniquely yours. Discover where forever begins at visitmarin.org and explore the weddings page for details.
I think we can also talk about maybe the common mistakes that people make when they are contacted by law enforcement in the pre-arrest investigation stage.
Well, the biggest mistake that somebody makes when they're contacted by law enforcement in the pre-arrest stage is talking to law enforcement.
Yeah.
The most that somebody should be saying to law enforcement is, can I give you a call back? Please, can I have your number, your name, your badge number, and I'll give you a call back.
Yes.
That's about it. Anything else is going to cause a problem. So put the phone, take the phone call, ask for their information, and then give it off to your defense attorney to handle it. Something that lawyers, doctors, professionals, I don't even know why I'm giving a caveat. Something that everybody needs to understand is you cannot talk your way out of these situations.
Yeah.
You can talk your way in to this situation where you get arrested, but you cannot talk your way out of it. There's just nobody that can. And it doesn't matter who you are. It doesn't matter that we do it for a living. It's not going to happen.
Yeah.
If the officers are going to arrest you, if they're there to arrest you, if they've made the decision in their investigation that it is time to arrest you, it is happening.
Yeah.
Let it happen. Shut your mouth. Be respectful, and let your lawyer handle it.
Yeah.
It's really it from that at that point.
Yeah, that's so true. And also I would, along with speaking, is also consenting to searches. Obviously, when you get arrested, the police are able to search your person and search you, but searching the inside of your house or maybe your phone. I have a pre-arrest right now where they're wanting to search my client's phone, and I'm like, "Do you have a warrant? Let me see the warrant. Come back with a warrant."
I have a client who his first interaction with law enforcement in this case was them serving a warrant to take his cell phone. So they took his phone, and then now he's been charged with aggravated battery and armed robbery with a firearm. That
process of search warrants on phones is such a brutal process because you're most likely never getting your phone back. And if you do, it's going to be at the very end of your case after they've extracted everything out of it.
Well, here's another big mistake: opening your phone for law enforcement.
Yeah, exactly.
Don't unlock your phone.
Exactly. Don't consent to that search.
You can't get into an iPhone.
Well,
you can get phone records from an iPhone, but getting into an iPhone and getting into the apps and stuff is something that there's terrorist attacks on the other side of the country where they couldn't get into the iPhones. I mean, I don't know.
If they have a search warrant, what they include in the search warrant for phones is the person who's the owner of the phone will provide all the passwords and all the whatever, so they can actually get into, and it won't just be the phone. It'll be social media or whatever else they have listed in there. But I've had a client in the past where they've searched their phone and they were in the warrant required them to provide all of the passwords and passcodes in it.
But still, they can't get into the phone.
Right.
The person would have to. But so a warrant can require you to give your password and everything else over.
But the consent on its own, if they don't have a warrant, then don't consent. Don't give them that.
Right. Well, of course, right.
Yeah. So that's huge. But I was thinking also the other mistake that people make is destroying evidence, and that's kind of related to the phone situation. And once you hear that police are investigating you or potentially something related to your phone, if you delete any evidence on there, you can then be charged with tampering because you've been notified that there was an investigation going on. So that's also another reason why you should have counsel, because there have been times where, it sucks to know that they're investigating your phone, but you cannot delete that evidence because that's a felony. You can get charged with a felony. So, and there are ways for them, if they do get a warrant later on, for them to see if it was on there and like later deleted, because it's always backed up into this like folder or whatever it is, where they can then extract it. And they have like their experts or whatever do their like computer things to get their extractions done. I don't really know the process of that, but
technology gets you. I mean, that's one of the things in as seeing it as a prosecutor and seeing it as a defense attorney, the technology that you have is usually the number one thing to get you caught. Or it's up there. It's up there because whether it's GPS data, conversations that you had, posts that you put up, when they can figure out where you were and what you were doing, and it's just from your phone, it turns your phone into your enemy when it comes to a criminal investigation.
Yeah, and it has like all of these, basically every app that you use, you pretty much consent to it tracking where you're at and what you're doing, or if you're sending messages, it has a backup, like Snapchat and all these things that you think go away after 24 hours. No, it's still in the cloud somewhere where they're able to retrieve that information if they need to, or if they have a warrant. So like those are other things that like you can later come up if you choose to delete or try to get rid of evidence. They can then come back with that. And another mistake is people contacting other people involved in the potential investigation. Oh my gosh.
Yeah.
Like I'm like cringing thinking about it.
Yeah. And I have seen that recently too. If you think that these other people are not being monitored
they might
by
be
law enforcement during this, I mean, there's an correct. And there could be a huge active investigation. You have to assume either that the phones are being listened to or that the information that you're sharing is going to make its way back to the police because the person's going to snitch, or the information is not just between the two of you.
Yeah. And that's huge because if you have an attorney, it's attorney-client privilege. Like even if they are tapped into your phones, they are not allowed to use that against you. They're not even allowed to be listening to it. Like that technically should be destroyed. But anything outside of that, if you're talking to anybody else that does not have like a privilege, which we can talk about privilege, that could be like with if you have, a spiritual leader that you confide in.
Rabbi, priest, doctor, psychologist.
Exactly. Those are the common privileges. Attorneys have that with their clients. So everything we talk about is protected. But when you talk to your friends about it over the phone, that could be, if they're listening to you, they can hear it. So like even people maybe not involved in the investigation, if you're contacting them and they're maybe tapped into something, you don't know if they have, they're listening to either your friend's line or your line, whatever it is. You could end up, providing evidence that you really shouldn't. If had you just hired an attorney and listened to them not to talk, that's the first thing I tell every client, do not talk to anybody about this case.
And I think if you hire an attorney from the beginning, that prevents a lot of these issues from happening because your attorney will advise you, hey, here are the things to not do and that you can do moving forward. But if the rules are laid out and the person understands them, they can avoid some of the traps. That doesn't happen for a person that doesn't know the law and doesn't know how the investigations work. So if you don't have an attorney, you're open to all of those problems happening.
Yeah.
You're open to being taken advantage of by law enforcement. You're open to being taken advantage of by co-defendants. You're open to being at risk of making your situation worse because of the things that you're going to say or do. Whereas having an attorney should advise you to not do those things, ideally. Yeah. And if you follow that, you're putting yourself in the best position given whatever situation you're in.
Yeah, and it's every single step of the way. It's advice like before you or law enforcement really do anything, before there's any movement on the case, which obviously law enforcement can go and get their warrant separate from contacting you or your attorney. But I oftentimes try to establish some sort of like rapport on the first phone call with the law enforcement officer that's like the head investigator. And I will tell them, if there is a warrant down the line for anything, please give us the courtesy and we will cooperate. And I do try to make it known. That's before I even know anything, but I just want them to know where we stand, because if you have a warrant, send it to me first, but if it's legit, it's good to go. Let's go. Like, what are we going to do about it? So that gives your client, like we said, opportunity to be mentally prepared, opportunity to prepare like physically in going into custody, because you go in, they take everything from you. If you don't want everything in their possession, you can just leave everything at home and go in, ready to go. But those are things that really are meant to protect people more than anything, and it's such a crucial stage out of all of the stages. Obviously, this entire thing is important because it comes down to someone's freedom and their livelihood and their future. But this could really affect so many different aspects of your life, especially if nobody wants an officer showing up to their work being like, "We're here to speak to XYZ." Like, it doesn't even matter if they're, talking about what it is that they're going to be talking about, or if they're there to arrest that person. Like, at that point, I think everybody will be like, oh no, like, why are they here? Why are they at my work of all places? Like, what is my employer going to think? Especially if you're a professional or maybe a teacher, you might have a job where you really can be investigated within your job just because a law enforcement officer showed up just to ask to speak with you. So that is huge. And I think that, if you have an attorney involved in that process, we can avoid that from even happening from the jump. It's like, okay, if you want to talk to them,
we can set up a time and a place to meet and talk.
Exactly.
If that's the way that it's supposed to happen.
Exactly.
That's a huge benefit to your client, because they don't have to deal with that embarrassment that you're talking about, and they don't have to worry about some of the collateral consequences of just a criminal investigation.
Right.
Because
Hi, it's Daniel from John Buys Bay Area Houses. Is your house more trouble than it's worth, dealing with endless repairs, frustrating tenants, or an inherited property that's just sitting there? You're not alone. A lot of homeowners feel stuck, not knowing where to start. That's where we come in. At John Buys Bay Area Houses, we make selling your house simple. Just call 510-800-JOHN or visit our website and you'll get a fair cash offer in minutes. We buy houses as is. That means no cleaning, no repairs, no agent fees or commissions. You choose your timeline, you skip the hassle. We handle the hard part so you can move on with confidence. Start fresh. Don't let your house hold you back. Call 510-800-JOHN or search online for John Buys Bay Area Houses to get your cash offer today. That's 510-800-JOHN.
Start fresh with John Buys Bay Area Houses.
remember, if the investigation goes nowhere and it ultimately becomes nothing, then great. Then that was just this little thing. But if you were at work when this was happening, now it's a whole big issue.
Yeah.
And people don't forget about the time when the police showed up to talk to you at work.
Yeah.
Or, you know, wherever you work, whether you work at Subway or you work at a high school, people don't forget that.
Yeah.
So avoiding that is huge, and having a defense attorney can do that.
Yeah. The other mistake people make is ignoring police entirely.
Altogether.
Yeah.
Yeah.
Which is not necessarily the worst mistake. I'd probably put it on the lowest. If you're going to make any mistake, this is probably the one to make, but I'm not condoning this.
Okay.
Just because ignoring the police can't really be used against you other than the police or state or government saying in court that you weren't cooperative.
Yeah.
And it
Some
will
consciousness of guilt arguments, I guess.
And it would, I mean, it just obviously would make the process harder, kind of like what we're talking about.
Mm-hmm.
But I don't see any, like, the worst harm that could come of that. You know what I mean? Because usually, like we said, the worst mistake you can make is speaking to law enforcement. So ignoring law enforcement can't be worse than that.
Fair. But if you know that law enforcement is investigating you, then there's a pretty good chance it's not going away.
Yes.
Whatever that investigation is, if you're aware of what it is, then you know this is probably not something that's going away. If you were involved in a collision or an accident and you left the scene and it was bad, you know it's not just going to go away.
Yeah.
So
Because they can continue. Your point is that they can continue their investigation.
Right. Whether they speak to you or not is not
Right.
going to prevent them from going forward with the investigation. They oftentimes can just, say, oh, well, we never got to your side of the story, so we decided it's time to arrest you. But that shouldn't ever be incentive to give your side of the story. That's just common police tactic that
Exactly.
if we get your side of the story, we just want your side, or we just want to hear your position or what you say happened.
Or that we're listening to all we're taking basically all the statements in consideration, and like
Right.
one of them is yours, even though you're like primary suspect. Like that oftentimes comes in like he said, she said cases or domestic cases, and that's like the worst is like when they trust, if it's a self-defense case and they start talking and it's like, then they're gonna flip it, and it's gonna be they admitted to touching them,
Well, that often happens is people think if they admit to something less serious than what the major issue is, then, that'll make it go away.
No.
That doesn't help.
No.
It doesn't happen.
Yeah.
And you'll just get in trouble for whatever that thing is.
Believe them when they tell you anything you say will be used against you.
Yeah, it will be.
It literally
It will be used against you.
Yeah. And then another mistake, and this kind of goes into talking to people on the phone, but putting things online. People love to put things on the internet, even if it's on your story. Stop putting your business out there.
Yeah, that's true. I think there are so many. I was shown a video on my way here today of somebody doing illegal tricks out on their motorcycle in front of somebody's house. And there's a big case going on in Broward with aggravated stalking. And anyways, this guy is revving and riding his motorcycle and like doing wheelies and stuff in front of another guy's house, and there's all these injunctions and things in place, and it's a nightmare situation in Broward.
Yeah, well then that stuff ends up coming into discovery because there's Ring cameras and
Yeah.
it goes on social media and there's screen record, and the police will be monitoring social media. Like they know that people will put it on the internet.
Yeah.
So that's an option for them to, and that's
It's not
they
just
don't-
the police. In this one case that I'm thinking of, the HOA is getting involved because they saw these videos of this guy doing this in front of his house. So stop.
Yeah.
Stop putting everything online. We put a lot online, okay? We're lawyers and we are trying to, market ourselves or market different messages or give people advice or give people entertainment. But that's fine compared to half of the things that we see, or more than half the things that we see online, where it's just like you can get likes and clicks without committing crimes online.
the most common thing I see online is usually people post it up with their guns. And the amount of times I've had that as evidence in like a delinquent in possession or a felon in possession case, I'm like, oh my gosh, like, did you really think this was a good idea? Like, did you think that this was something? Because also law enforcement, if they're heavily policing a certain community, they start getting familiar with faces and they start knowing people in the community and they start knowing their nicknames or their street names or whatever. And at that point, they're like just checking for fun. They're like, let me see what Smokey's up to this weekend.
Yeah, and oftentimes Smokey is putting on a pound of marijuana, his gun, and, illegal gummies and whatever else, and just Snapchatting it
wad
out.
of
And just
cash.
like, yeah, it's like, you don't need to do that.
Yeah, that's
That's
not
making
do that.
our jobs harder.
Much harder.
Because they will inevitably get in trouble for it. And it does make our jobs more difficult to say that they are, innocent and try to mitigate the situation. When you're especially talking to prosecutors and you're trying to go into how good of a person your client is and why they shouldn't throw the book at them, when they flip through their file and they pull out a picture of your client with a stack of cash, a grill, and a pound of weed,
Clearly thinking he
it's
looks
not
real
great.
cool.
Right.
Yeah.
It's not great. It
Yeah.
takes away from the argument that he's a really great, member in the community. Maybe he is.
Yeah.
But posting that stuff doesn't help.
No, not even a little bit.
And it often comes back around and hurts the case.
Yeah, and you don't know who might be snitching on you or who may, like, even if it's on your close friends or whatever, like, maybe you're like, oh, maybe I won't put it on my full story. No, Do not put it anywhere, because if it's on, even on your close friends, you don't know. Maybe if you, let's say it's a drug case where it's like you're saying, like guns, drugs involved in the photos, money in the photos. That could be maybe a trafficking charge, or it could be with intent to sell, whatever it is. And if somebody that you sold to is being investigated, they have an incentive to be like, this is my dealer, because usually the officers are not interested in the buyer. I mean, yeah, the buyer might get a simple possession charge, but if they are cooperative, they usually avoid it, or it gets reduced. They're usually after big dog, or the guy that's running the enterprise, or the guy that's doing all the sales. So they're trying to go after that guy. And if they have that to show, like that's this guy is actually involved in whatever, and oftentimes it is. I've had cases, it's always like the drug cases, the firearm cases, where it's like those are pieces of evidence. I always get where it's like they're posted up online with their photos and like their guns and their drugs, whether it's weed or not. And then they end up, that leads to another piece of the investigation. They start following them around, and then they get a warrant, and then the whole thing just trickles into another thing. But you do not know who's watching your story, even if you think you trust them. Do not post that. You know,
and for the real drug dealers, their bosses are watching.
Yeah.
That's going to be bad. You don't see the top bosses posting on TikTok with like their money and
they're
guns
low key, very low key,
and tigers and whatever else they own. Like, you don't see that. There's a reason, because they don't want to get in trouble for dumb things.
Yeah.
And if you are already committing a law violation, don't commit another one at the same time. That's what I had my criminal law professor in law school, Megan Cheney, who I love to death. One of the things she said was never commit 2 crimes at once. If you think about it, like your odds and the chances of you getting in more trouble are coming from that second, that other offense.
Oh my God, that's so true.
You have drugs in your car. You weren't going to get stopped if you weren't speeding. There's just certain things that you don't need to commit 2 crimes at once. So if you are out there and you are selling drugs, don't put it online.
Yeah.
It's pretty simple.
Yeah. And it's also like, it comes down to also like, to that point, consciousness of guilt. The government loves to use opportunities to say that this person did X, Y, and Z after they committed this crime, whether it's a new crime or maybe not a new crime, but kind of sketchy. They can use that act to show that you were acting that way to avoid getting in trouble because you knew you did something wrong. And that's something we call consciousness of guilt. Mm-hmm. And that is oftentimes their opportunity to be like, well, that's how they did this with criminal intent.
That's how the state often proves intent, is through the guilty mind of the person and showing, oh, clearly they're guilty, they ran. Clearly they're guilty, they refused to give a breath sample.
Oh my God.
That's a very easy way for prosecutors to prove parts of their cases. And if you're giving them all of that ammunition on social media through pictures of things like ammunition, it is a problem.
Yeah, exactly. So I would say in terms of pre-arrest, the most important thing is make sure you are honest with your lawyer as well. Like, if that stuff has already been done, like in the past, and you are now realizing that there's things that were put out into the social media world or internet where things could come back and bite you, if you are aware or thinking about it because you got that call from the police, let your attorney know, so that way we are able to kind of mitigate as much as possible, or maybe try to understand what the police are trying to get, or if they are privy to that information. Because oftentimes I don't volunteer information to law enforcement. They have to do their own job and try to figure that out. But I'll, try to finesse my question to be like, what do you guys got against my client?
That was some finessing. Well, what do you guys have?
Real smooth.
Yeah, that's some some killer finessing.
Yeah, it usually depends on what's going on, but I'll be like, yeah, so like, why are you here?
Guys, why are you guys? I heard you're investigating my client. What's up with that?
Tell me more about why you're calling us, please.
Yeah,
I'm their attorney. What do you want? And then they're like, yeah,
that gets you real far.
Yeah, I mean, usually get something.
Yeah. Well, you can be friendly when you invoke your client's rights.
Yeah, why not?
I try to be nice when I invoke my client's rights.
always, because then I'm like, but if you have a warrant, call me.
Right. My client won't be saying anything to you,
Yeah.
but
Exactly.
feel free to say things to me.
Yes.
Well,
And also the benefit of having an attorney, and I probably said this, but I just like think it needs to be, and you did say this actually, is that like direct all communication to me, is that like at that point your client's not getting calls from law enforcement anymore. Once you step in, law enforcement is required to talk to you to get to your client. So that's huge. I think that's a huge, huge, huge protection. Like there's so much anxiety associated with people speaking to police, even in general, or just like getting that call, you know?
right.
So
I have anxiety thinking about my clients speaking to police.
me too. Me too. That's
So
like,
I don't want that.
no, not even a
Right.
little bit. It's like, please put me on the phone and hang up. Thank
Right.
you.
Right. You don't need to talk to the police anymore.
No, I've got it covered.
I think the big takeaway is when somebody is aware that they are under investigation, hire a lawyer.
Immediately.
That's it. That's the first step. That should be the only step. Hire a lawyer. If you get a phone call from the police and the police are saying to you that you're under investigation, ask them for their information, tell them that you will get back to them, and you give that information to your lawyer and let your lawyer do that. And that's
Exactly.
the safest way to handle it.
Yeah. Because you have to remember the objective of law enforcement, it's to make an arrest.
Make an arrest and close the case.
Yeah. So
Yeah.
they're not trying to, their objective is not to protect you. It's not to be there for you. None of that. That's
No.
your attorney's job to handle everything for you and protect your rights and protect your liberty. So hire an attorney if you get a call from law enforcement or know that you're involved in an investigation, and don't make any of the mistakes that we've discussed. Because
Let us tell them to come back with a warrant.
Yeah.
You don't need to do that. Let
Yeah.
us do that for you.
Exactly. So I think that wraps up today's episode. Make sure you check the show notes and like, follow, subscribe, and leave us a 5-star review. We are at comebackwithawarrant.pod on all platforms. And if you don't like listening to us,
Come back with a warrant. You get it at this point.
make sure you come back with a warrant.
This episode is brought to you by Progressive Insurance. What if comparing car insurance rates was as easy as putting on your favorite podcast? With Progressive, it is. Just visit the Progressive website to quote with all the coverages you want. You'll see Progressive's direct rate, then their tool will provide options from other companies so you can compare. All you need to do is choose the rate and coverage you like. Quote today at Progressive.com to join the over 28 million drivers who trust Progressive. Progressive Casualty Insurance Company and Affiliates. Comparison rates not available in all states or situations. Prices vary based on how you buy.